The floor is yours. Come forward. Good afternoon.
May I reserve 2 minutes for rebuttal?
2 minutes, certainly. All right, Mr. Hadley, the floor is yours.
Thank you, Your Honor. May it please the court. My name is Edward Hadley. I'm a member of the Nashville Bar, and I represent the appellate, Margaret Bush Wright. The issue before the court is simply this: whether the trial court erred in failing to award the mother her attorney's fees. We submit the answer is yes. We ask this court to reverse the trial court's determination that there was no prevailing party. We ask this court to find as a matter of law that the mother is the prevailing party, and we ask this court to remand the case to the trial court for determination of the amount of fees to be awarded. To begin with, this case is rooted first in the marital dissolution agreement provision that provides for an award of attorney's fees. And it says this: in the event that it becomes reasonably necessary for either party to institute legal proceedings to procure enforcement of any provision of this agreement, the prevailing party shall be entitled to a judgment for attorney's fees, costs, and other reasonable expenses incurred in prosecuting or defending said action. That sets the stage. I don't think there's much dispute between the parties as to whether it applies or what that language means or says. The real crux of the issue is who is the prevailing party when we apply that language. Is it the mother or the father? I respectfully submit that the trial court interpreted the language incorrectly and applied the facts incorrectly. So looking first at the legal standard applied, the trial court looked at the Fannin case, 2010.
Even before we get there, what is the standard of review in this case?
Great.
In terms of
Yes, sir.
determining who the prevailing party is?
Absolutely. The standard of review is de novo when it goes to interpretation of the MDA and its application to determine who is the prevailing party. I know between these parties here, there is some debate in the brief about whether an abuse of discretion standard applies. And the Boone case mentions both. In fact, Justices Clement and Bennett, who participated in that opinion, cited both. But when it discussed, that opinion discussed the language of the MDA for the attorney's fees provision and its interpretation and application to determine the prevailing party, the standard of review was de novo with no presumption of correctness, and I submit that applies in this case. Were there an award, perhaps, and there was a debate as to the reasonableness of that award, then an abuse of discretion might apply. As for the motion to alter or amend, procedurally, the granting or denial of that would be subject to an abuse of discretion standard, but the substantive issue raised by that motion is the legal issue presented by the MDA language and its application to the facts, and I submit that that is a de novo standard of review. So for the issues before the court,
does it matter at all that the contract didn't define the term prevailing party? Is that of any consequence in terms of what the standard of review is in this case?
I think it is in the sense that it presents a matter of law, because the only way for this court to go and determine what does the prevailing party term mean in this appeal is to look to the case law. And starting with Fannin and its recitation of principles from United States Supreme Court language, down all the way to the Colley case from the Tennessee Supreme Court and the Boone case from this court, to tell us how should that term prevailing party be interpreted. And that is a de novo review matter of law. So when we look to the Boone and Colley case, I think there's a few takeaways that we should draw. One is, in deciding who is the prevailing party, what about all these little skirmishes along the course of litigation? And here you'll see in the appellee's brief a long recitation of all the skirmishes that take place in the course of litigation. If you go back and read Colley and Boone, those skirmishes happened there. In fact, in Boone, the wife was even sanctioned, and those sanctions upheld appellate review, yet she was still the prevailing party. And so the takeaway is that these skirmishes are not necessarily relevant to who is the prevailing party. The standard later tells us that. It's like a football game where one team prevails. The score's 14-7, the team with 14 points prevailed. They might have had a turnover. They might have fumbled the ball. They might have had penalties against them, but they put more points on the board and they prevailed. Similar here. So the problem with the trial court finding was that the trial court used a standard that was based on the Spanos case and the Griffin case and said both parties were partially successful. And that standard was wrong, and here's why. Both of those cases did not involve a contractual provision. Both involved an award under Tennessee Code Annotated 36-5103C. Also, they involved the older version, not today's version of that statute. The old version did not include the term prevailing party. Instead, it said a spouse or a plaintiff's spouse, and then it also said may recover in enforcing the MDA. So it was also discretionary. Now, the today version of that statute says prevailing party, but nonetheless, that statute or those cases should not apply where there was this partial everybody won, everybody got a trophy approach, because, again, it involved a statute that's not applicable in this particular case. So the correct standard is the language of the MDA, and the appellee raises a good point. Well, it says enforcement, not modification, so we should only look at legal proceedings instituted to enforce the MDA, not to necessarily change it or modify it to say something else. Even if we use that standard, the mother is still the prevailing party, and I think Boone and Colley both give us guidance on that. For procuring enforcement is the language here. This MDA doesn't just say a legal action to enforce the MDA, it says to procure enforcement. Procuring may include strategic moves. It may include motions, contempt hearings. It might include a deposition or other discovery tactics to ultimately lead to enforcement of that. The Boone opinion, footnote 6, recognizes this. They mention in footnote 6 that in another case, the language said related to enforcement, and that was a broader term than just legal proceedings to enforce. So I respectfully submit that the inclusion of procuring enforcement in the MDA in this case is a broader perspective than merely legal proceedings to enforce. And then also we see that the language includes prosecuting or defending, and that's important under Boone and Colley as well. So if we look on the broadest sense and look at the U.S. Supreme Court opinions, we have any kind of a prevailing party is anyone that has successfully achieved a material alteration in the legal relationship of the parties. On a much narrower view, maybe looking at Colley or Boone, we have the fact that a prevailing party can be one who successfully defends a claim that is ultimately voluntarily dismissed by the adverse party. The defender can still be the prevailing party. Our position is under either the broader standard or the more narrower standard, the mother is the prevailing party. So if we look to the facts, let's look narrowly at enforcement only. The mother achieved enforcement on two significant grounds. One was past due alimony, $33,000. The second was past due child support at $16,000. That was purely enforcement. An existing MDA said, you have to pay this. The father didn't pay it. He ended up voluntarily paying it in the course of the litigation before it was actually decided by the court and even before the settlement. Nonetheless, though, he wasn't paying it. Mother filed the action. They prosecuted the action through deposition, and then he did pay it. So that is procuring enforcement, and she is a prevailing party. If we flip that around and look at her defensive posture, the father had one counterclaim, one claim, and he wanted to modify the parenting plan so that instead of having joint decision-making authority, he would have total joint decision-making authority, total. And he lost on that. So the mother successfully defended. So on the narrowest view of enforcement, mother prevails. Again, she's the prevailing party, not father. If we broaden that out, then we can look at the fact that mother succeeded in increasing the child support increasing past due child support, and getting a $3,000 judgment. Those would entitle to her as a status as the prevailing party on a broader view. Now, the trial court also erred factually, and the first factual errors, the trial court never mentioned or failed to consider the two awards I just mentioned that the mother got, which were the past due alimony, $33,000, and $16,000 for past due child support. Again, pure enforcement, not modification. The second factual error by the trial court was a finding that the father was partially successful. Now, again, that's the wrong standard. It's the wrong statute. It doesn't apply here. But even if you look at the factual finding itself, there were three bases for that in the trial court. 1 and 2 were termination of alimony, and second, termination of life insurance guaranteeing that alimony. And here's why that's not a prevailing point. It's because the only reason that the alimony was terminated is because the mother remarried. It had nothing whatsoever to do with the litigation itself. The MDA says the alimony terminates on mother's remarriage. She married while the case was pending. Alimony was terminated. That's it. We cited cases in the briefs that say that is not a basis for prevailing party. The third ground found by the trial court was, quote, removal of various contractual obligations from the MDA, end quote. We don't even know what those are. They're not cited. They're not discussed. And again, if we look at modification versus enforcement, those would still fall in the modification bucket and wouldn't even be considered under the narrowest standard. So that is a failure of the record and a proof, because the trial court's finding that number 3 is not supported.
So are
by
you
the record.
suggesting that modification can never be procuring enforcement?
No, not at all. In fact, I say that it can be. It can be and should be, because procuring enforcement is a broader term. It's an indirect term versus strictly enforcing what's written there. So I suggest that procuring enforcement can be broader and can include modification. But if you look factually and decide, okay, we'll consider modification, who prevails, it is certainly the mother under that broader examination as well, because not only did she get enforcement, but she also modified the terms of the order going forward as well. Thank you.
All right, thank you, Mr. Hadley. We'll hear from you again on rebuttal. Good afternoon.
Good afternoon. May it please the court, my name is Caroline Altschuler, and I represent the appellee, Dr. Ronald Wright, in this case. It's important to note that at the trial court level, there was never a final hearing. There was no evidence that was entered before the trier of fact. There was no testimony presented. There was no adjudication on the merits. What happened is that we went to an intensive 8-hour mediation where we brokered negotiations and had mutual compromise, resulting in a modified parenting plan and an agreed order entered in August of 2023. The only issues that were reserved was his claims for attorney's fees. We submitted our briefings to the trial court, and the judge properly declined to award fees. This issue of fees is not a first impression in this court whatsoever. It's well established that a litigant does not have a right to have their fees paid by the other party absent contract or statute. And Eberbach does make clear.
I want to ask you the same question I asked opposing counsel. What is our standard of review of the trial court's determination as to who the prevailing party is in this case? Is it de novo? Is it abuse of discretion? What's the appropriate standard of review here?
Definitely reviewing the contract would be de novo standard, absolutely, of determining the terms. But in determining the legal standard, that does fall under abuse of discretion, especially when the court considered also the statutory scheme of TCA 365103C and also declined fees under that statute as well would be abuse of discretion. But review of the contract is de novo. And in looking at the contract, paragraph 19, as noted by opposing counsel, It states that the prevailing party who has instituted proceedings to procure enforcement is entitled to an award of fees. But enforcement did not occur in this case. The resulting relief from this case was modification. And to Judge Bennett's question earlier,
Isn't a $33,000 judgment for past due alimony enforcement?
there was no judgment for that. No, there's actually no claim made by the mother in any of her underlying pleadings for a request for alimony to be paid. That's not in the record whatsoever.
That's not in the complaint.
No, it's not in the complaint. There's no claim for alimony in her complaint.
What is in the complaint?
In her complaint, she had a request to modify the parenting plan to request sole decision making. She later requested to modify the day-to-day schedule that was wanting to award the father very minimal parenting time. That was defeated against. She was requesting that personal property from the divorce be returned to her. That had occurred 5 years before this ever happened. She was requesting oral agreement that the parties had for airfare that had nothing to do with the MDA, that the father had somehow breached that. She was requesting certain payments under these contractual obligations that were later removed from the modified parenting plan. And then there were contempt charges against him on child support. Again, there's no finding whatsoever that there's no judgment for child support payments. There's no finding. There's no facts in the record.
So if I look at the complaint, I'm not going to find a request to for an award of past child support or past alimony.
Not for past alimony. There was a request for past child support, but again, there's no finding whatsoever or a judgment for past child support at all.
The parties entered into an agreement that she would be paid $16,000 in past child support.
That was retroactive modification, the $16,000. I think it was $13,000 actually.
But it was a judgment for past due child support.
It was retroactive modification. So in the modified parenting plan, his child support obligation went up to $2,100 a month, and so we actually compromised of, instead of doing retroactive to the date of filing, that we would do halfway. So that's how we came to the $13,000. It had nothing to do with past due payments whatsoever, because he had been paying child support. This was just the retroactive upward from the modification, if that makes sense. It wasn't for contempt in any event. And so that's where there's no facts in the record, and these allegations that opposing counsel continues to make.
Well, do we need findings of fact? Can't we just look to see, did she procure enforcement of the MDA? We don't need a finding of fact. We look at the end result.
Yeah. Well, yes, but I think in the end result, in the agreed order, there is no judgment that he allegedly didn't pay child support, and there's no facts.
There's nothing in the record that says he shall pay $16,000 in child support.
Again, that's for the retroactive modification piece, so it's different. It's not for enforcement.
Is there a judgment that says he owes and shall pay $16,000 in child support?
For retroactive modification,
So
yes.
the answer is yes.
Yes, but
Thank you.
yes. But the distinction I'm trying to make is that it was not relating to any contempt allegation. It was for modification. And so ultimately, when the court released its opinion in determining prevailing party, determined that both parties had achieved beneficial results in the case. It was a mediated agreement. And so, yes, the day-to-day schedule was modified, but that was due only to the age and preference of the 17-year-old daughter. There was no sinister reason for modifying the parenting plan. With decision-making, the mother was awarded that, but because both parties agreed openly that they could not effectively communicate. But in tandem with that, the father's financial contributions were tightly capped, and the mother was ordered to indemnify and hold him harmless from the decisions that she made. Of key importance to us, and what the trial court noted, was that the father successfully removed contractual provisions from the original parenting plan. And that required him to pay private school tuition, required him to pay 100% of all extracurricular activities, 100% of medical expenses, required him to pay vehicles for all of the 3 adult children at that time.
Was that new? Was all that new?
That was in the original parenting plan. So in our modified plan, we were able to successfully remove that. And the father had attempted to remove that before in prior iteration.
And is that procuring enforcement?
No, that's
not.
modification.
Okay.
No, modification.
So it's not something anyone should get attorney's fees for?
Correct. And we were not
Okay.
asking for that, but that is what the court was using to say that both parties obtained beneficial results in this case because the father was able to remove hundreds of thousands of dollars worth of obligations from the original parenting plan in this modified parent plan. Likewise, his alimony obligation was terminated, along with the obligation to carry a life insurance policy, among other items of relief that were outlined in my brief. And again, there were exhaustive, I mean, this was like a 27-page petition of alleged enforcement actions against the father that he defended against. So ultimately, the trial court did properly find that neither party could be defined as a prevailing party, and this analysis is consistent with uniform body of law from this court, that where both parties are partially successful in their claims and defenses, there can be no prevailing party. Especially in a settlement agreement. I cited a case in Nathaniel C.T. where this court noted that the case resulted in a mediated agreement, thereby the court's hard-pressed to find a prevailing party. Finally, Mother had argued in her brief that the trial court should consider the relative success of the parties to each other to declare a singular prevailing party in the case. And I don't think that's possible, how a court could quantify who won more. I think a reasonable person would agree, especially from the father's perspective, that removal of those contractual provisions that obligated him to hundreds of thousands of dollars was a beneficial result. And so the trial court recognized that and properly declined to award fees to Mother. We're asking that that be upheld, and we're asking that the father's appellate fees be awarded to him. I do want to note the Boone case that was raised by opposing counsel. In that case, that was also a post-divorce litigation, but it was a declaratory judgment action that was filed. And this court stated the parties are missing the first step in the analysis, which is what does the MDA provision state? And the MDA provision for attorney's fees was procurement of enforcement, same as in this case, and therefore determined that even though the father prevailed on his declaratory judgment action, that did not fall under the scope of the MDA, and therefore he was not it was proper to decline his fees. So I would submit that Boone is a very instructive case to consider. But ultimately, this was not about enforcement. This was about modification, this case. Thank you.
All right, thank you, Ms. Altshuler. Mr. Hadley?
Yes, Your Honor. I'll try to clear up the record onto a couple of points. When the complaint was initially filed, the father was paying alimony. During the course of the litigation, he stopped. There was not an amended complaint filed adding that claim for alimony. However, there was a motion for contempt filed, and this is discussed on page 30 of the appellant's primary brief. Had the case progressed, then the petition or the complaint would have been amended to include that before trial, or under the authority of Jones versus Jones, which is an unpublished opinion we cited there on page 30 of our brief, the issue would have been properly before the court and tried by implied consent because it was presented by the pleadings and addressed by both parties. That's how that came to be. The second issue is these payments. There are three. There's a $33,000 alimony back pay. There is a $16,000 child support back pay. There's a third child support, $13,000 and change. That goes to the modification. When child support was increased, it was dated back to an earlier date. That's the $13,000. So there are three different amounts of money there. The motion for contempt for non-payment of alimony is in volume 2, page 143 of the record. The evidence of the $33,000 and the $16,000 is at volume 4 of the record, pages 406 and pages 540 and 541. Our brief discusses these points on pages 29 through 32. That's our appellant's primary brief. One thing to consider when these parties have to bring a complaint, res judicata, claim preclusion requires every claim that could have been brought to be included. And that's why sometimes we have to focus on the winning issues and not look at all the skirmishes. Thank you.
All right. Thank you, Mr. Hadley and Ms. Altshuler, for your arguments. We'll take this matter under advisement. Certainly. Mm-hmm.